Chairman, Director, thank you for your openness and candor on a number of subjects. I've got one more. ICE policy of releasing removable criminal aliens under priority enforcement program and the use of prosecutorial discretion has led to some tragic consequences. No one doubts that we've had multiple, and they generally make national news for obvious reasons. But reports indicate that 83% of aliens released nationwide between 2012 and 2016 were convicted felons, and 30% of them committed serious felony offenses such as rape, child molestation, and attempted murder after the release from ICE. Again, 30% committed additional felonies after their release. Given the danger of recidivism by these individuals, or another way of putting it, Director, consider that in your discretion you've been wrong 30% of the time and people have died, people have been raped, people have been molested. Isn't it, in fact, time to change that discretion to make it less permissive?
I'm not sure where that is coming from, Congressman, with respect to we've been wrong 30% of the time. If you're talking about total releases, that's one number, but as I explained earlier, 2/3 of those releases are not at our discretion. Only about 37% are. And in those cases, we take very good care in reviewing files to ensure that there is a basis for that release. We don't, the women and men of ICE do not want to see a single immigrant go back and commit a criminal act. We're doing the best we can. Are we perfect? We're not. I have to admit that.
Okay. Well, let's look at it another way. Under Rodriguez, currently, if you do not foresee finishing the adjudication of a case after 6 months, you're obliged to release a non-legal immigrant, someone who came here illegally, who you're attempting to deport, and when you release them, they generally disappear, and unless you catch them again, they don't show up. Isn't that correct?
Many times.
So for this committee, the Committee of Jurisdiction, to change the law, even to change the Constitution if needed, isn't this a problem that currently either you do not have the tools to adjudicate a case within 6 months, or the courts are not available to you for an expeditious 6 month, and you're being forced to release knowingly people who enter the country illegally, are appropriate for deportation, often violent criminals, and yet you're forced to release them under current Supreme Court decision and Ninth Circuit, right?
That's true.
So if we look at both sides of the aisle here and we were to look prospectively into next Congress, isn't the most important tool we would give you a pair of tools? One, the ability to adjudicate cases in less than 6 months so that you do not come up against the mandatory release, and sufficient assets to, in fact, ensure that you never have to release somebody simply because you don't have the capacity to hold them.
That certainly would be helpful, and if I can add to that point, and I would love to sit with anybody who is looking at this issue in particular to assist in any way I can. But with respect to those people that were required to release under the Supreme Court decision, many of them, and probably the majority, are because we can't get travel documents. And that's why, from the country to which they need to be repatriated. And that's why we're working so hard to try to, with those foreign governments, to try to change that.
Well, and let me do a final question in my remaining 1 minute, and I'll leave you plenty of time for an answer. Don't you, I also serve on Foreign Affairs, and my colleague, Mr. Shabbat, and I serve together. Wouldn't it be, at a bare minimum, appropriate to provide the Department of State the insistence on your behalf through the Secretary Johnson that, in fact, there be an outcome, meaning visas which are granted by the State Department should be withheld by countries who refuse to take back the individuals who have committed crimes, done other wrong things, and for which we want to return them to their home country? Isn't that really the quid pro quo that should exist, where Secretary Johnson should be able to get the Secretary of State to use his authority to effectively stop granting visas, at least reduce them to countries that are not cooperating. Isn't that a back and forth that the next administration is going to have to deal with?
I think so, and the Secretary is very much aware of that, and he has taken under advisement how he should exercise that authority.
Has he made that request to the Secretary of State?
As I said earlier, I believe he has one seriously under consideration. I don't know that the letter has actually been exchanged, but I do know he's aware of it.
Okay, thank you, Mr. Chairman.